Good morning everybody. We will start today's discussion on the concept of the relationship between the banker and the customer. As earlier we had learned about the relationship between a banker and a customer. That relationship was general relationship, and today's content is on the basis of special relationship, that is between a banker and a customer. What do you understand by special relationship? The special relationship is referred to as the special obligations and rights of the banker against the customer and vice versa. What do you mean by obligations? Obligations are nothing but a voluntary acceptance of the responsibilities and the duties which we feel we have to fulfill to complete our responsibility. So as a banker and a customer, there are certain special obligations and rights of the banker against the customer. The obligations of banker towards the customer. Obligations of the banker. There are obligations of the banker to honor the customer's check. That is, it is an obligation to pay check if otherwise in order. That means whenever a customer gives a check to the banker, then it is the duty of the bank to pay the check of the amount being specified on it. It cannot deny telling, I have no money with me, I cannot give the money today, I can't do it. He cannot deny it. If there is a balance in the account of the customer, then it is the obligation of the banker to pay the check as said in the check. That is the meaning, obligation to pay checks if otherwise in order. Bank's liability for wrongful dishonor of a check. That means to say, bank is held liable if it wrongfully dishonors. What do you mean by wrongfully dishonors? If you have given a check for payment to a trader, and when the trader gives a check to the bank for his payments, the bank say there is insufficient fund, the check is dishonored, though there is sufficiency of fund in his account. In such situation, it is the bank's liability for wrongful dishonor. That means bank will be held responsible if it does the dishonor wrongfully. The secondly, conditions when a banker may refuse the payment of a check. There are situations where the banker can refuse it. Those situations is when the fund is insufficient, when the check is not properly drawn on the proper form, not properly signed. I think it's a basic knowledge that everybody knows that whenever you fill a check, the check should be properly drawn. That is, to whom you are drawing the check, the date, the amount, what has been said in words and figures should match, the signature, and no short forms or abbreviations should be used in the check, and it should not be written again and again, no scratching, or it should not be worn down or toned down, and not such things must be followed. It must be presented within the time limit, within the working hours when the check is been given. When all these things has been conditions being taken by the banker, he may refuse to payment of conditions when a banker may refuse. But that is when you don't have money in your account, when it is not being properly drawn. That is, you know the format. As I said, you know generally how to fill it. When you don't fill it in proper way, the word said is different with figures given. The date is being written scratched, written once again. It has been torn out. It is not properly drawn. In all these situations, the banker will not be held liable. He can refuse the payment of a check. So what I need to say here is, there are certain obligations. In that obligations, the first and the foremost obligation of a banker is to pay the checks, is to honor the checks. So when does he honor the check? When he finds that there is sufficient funds available to pay the customer's check in the account of the customer, when the account of the customer has sufficiency of the funds. Otherwise, he may dishonor it. If the funds of the customer which is available in hands of the banker for the payment of the check. The banker should pay the check only if it is complete. It is an order presented with a reasonable time after the date of issue. The banker need not honor the check of a customer if there is a legal order issued for non-payment. Sometimes there will be some legal orders being given as an instruction to the banker not to go for payments. Bankers have an obligation to honor the check against the overdrafts. Bankers can dishonor his customer's check under certain circumstances such as insufficient fund, irregularities in check, presentation of the check after it is paid, presentation of the post-dated check before the due date. The obligations of the banker to compensate the customer for wrongful dishonor of a check. So it's very clear that a banker has an obligation towards his customer to pay his check if otherwise in order. Further, to understand the obligations of the bank in the special relationship is to maintain secrecy of the customer's account. The bank owes a contractual duty not to disclose the customer's financial position without his consent. Contractual duty, that means as an agreement between the banker and the customer, the banker has to maintain confidentiality regarding the bankers have to do it. That agreement says between the banker and customer that they have to not to disclose the customer's financial position without his permission. Consent in a sense, if I say you can give, if I say don't give it, then he need not give it to anybody. However, the obligation of the secrecy is not considered essential. Sometimes you need not maintain the secrecy. What are those situations when the obligation is not considered essential? That is, when a banker is required to give evidence, suppose in a court of law you have to give as an evidence, then you need not worry about the secrecy. When there is a national emergency and the disclosure is essential in the public interest, when there are clear proof of the reasons to the state, when a consent is given by customer to provide the information for the preparation of the balance sheet and other things. Thus, what does this clearly make us to understand that the banker must not disclose to any of the outsiders the details concerning the customer's account. That is, check deposited, drafts, bill deposited, from whom received, to whom issued, what is the balance of account, what is the security deposits by the customer, and other related factors. So you need not disclose any of these issues. The secretary has to, the secrecy has to be maintained because relationship between banker and the customer is confidential. It is private in character. Precautions to be taken by the banker. When I have to say you can disclose doesn't mean you just speak on, you just tell on whatever you want. There are certain things, certain precautions must be taken by banker in answering these inquiries. That is, you should not be negligent in giving. As a banker, it is his responsibility that when he gives the information, he has to give the information in what manner. That is, you should not be negligent in giving information. The information should be given confidentially. The information should be given honestly. Information given should be based on facts. It should be given in most general manner. That means it's something where you are able to understand it. Whatever required, so much been said. That is what it means to say general manner. When you give the information, it should be based on facts. That means to say it should not be something illusion, something creative, not just like that spoken, not like that. You have a proof, you have an evidence, on that basis you give the information. And never give information in a dishonest manner. It means it should be truthful. It should be confidential with truth. And what is there, it has to be said. It is not with any personal relationships, you have to give the information. So whenever you give an information, ensure that you will not give it in a negligent manner. you give it confidentially, you give it honestly, it will be based on the facts what you have with you, and it will be given in a most general manner. You should not make any false statements. If he makes, then the bank will be held liable for a fraudulent representation, compensation as the case is. For safety, he has to mention he is not responsible for the information provided, because nobody should say you gave, so I used it, so I am in trouble now, you saved me. That should not happen to the banker. So what the banker does is, okay, I give the information, but for his safety he says I am not responsible for whatever the information being provided. He will express his consent telling that I am giving the information only because my customer has told me to provide you. So for all the inquiries being asked to the banker, it is his obligation that he will maintain secrecy, but that secrecy, if being asked to disclose, then he will take all those precautions in disclosing and answering to the inquiries. So this is what you have to understand, the relationship, how the relationship runs between the banker and the customer. The first thing, it runs as an obligation for him that he has to honor check. The next thing says is obligation for him to maintain secrecy of the customer account. The further thing what it says is the banker's obligation and able to understand his duties and responsibilities, we have to understand about his right. That is banker's right of general lien. So we understood with the obligations. Let's know what are his rights. So understanding with his rights, we are able to get to the word banker's lien, and there is a word called lien. We know who is a banker, there is nothing to say on it, but we should know what is lien. Here the lien has been defined as the right of a creditor to retain the possession, not possession, it means to say the possession of the goods and securities owned by the debtor until the debt has been paid. What does it mean to say? It means it is a right of a creditor. It is given right to the creditor that he can retain, means he can keep it with him. The possession in essence, he can hold the goods with himself, owned by the debtor. Whoever is a debtor, he can ask him that I am holding your goods in my possession until you pay me the debts. This is what is called as a lien. So lien has been defined as a right of a creditor to retain the possession of the goods and securities owned by the debtor until the debt has been paid. So lien is available only on the goods and securities only. For example, bills, checks, promissory notes, share certificates, bonds, debentures, etc. So I think you are very clear now what a lien is and what lien is for. It is only for goods and securities. When you go further in understanding on lien, it is divided into two categories. The two categories are general lien and particular lien. What it means then? What is a particular lien? What is a general lien? We have to understand it. A particular lien. What is a particular lien? A particular lien conforms to a right to retain the goods in connection with which a particular debt arose. What it means to say is, a tailor has a right to retain the clothes made by him. So whatever the clothes he has stitched, those clothes is only clothes that he can retain with him of his customer until his tailoring charges are paid by the customer. I think you are able to understand the concept of particular lien is, I have taken a loan for a particular property. That particular property on which the loan has been taken indicates that if you are confirmed with the right of particular lien, then you have a right only to retain the goods. That is the building for which I have taken the loan. Not any other things what I have with me can be retained by you. That means a particular lien confirms to a right to retain the goods in connection with which a particular debt arose on that debt, on that product, on that property. Whatever it is, on that particular thing you have taken a loan, on that particular thing you can possess it. So thus a particular lien applies to one transaction or certain transaction only, and a particular lien is a right of the creditor to retain particular property until particular debt is repaid. So I'll repeat, particular lien is a right of the creditor to retain particular property until the particular debt is repaid. On understanding what a particular lien, I think you should be able to understand what general lien is. Now, to understand this, a general lien means a right to the creditor to retain the possession till all amount due from the debtor are paid. So I have taken around 10 lakh rupees from the person, from the creditor. So now as a debtor, until I give him back the 10 lakh rupees, the creditor can hold the possession of all the things what I have relating to me with him. That is called general lien. But in particular lien, it is not like that. In a particular lien, he has a possession to hold only that particular property for which you have taken the debt. But in general lien, he can hold the right to possess all the things whatever I have till I discharge my amount due. This is available to the bankers, to the intermediaries, attorneys of high court, brokers only. So a banker is given the general lien against his borrowers. Under the banker's lien, the banker is authorized to retain the securities in respect of the general due by their owner to the banker. The banker can retain all the properties which have been received from the owner legally. So this is what you mean to say a general lien. So to make you clear, a general lien is the right of the creditor to retain any property until the general balance is repaid. Thus, general lien is conferred on bankers by custom or usage of trade, but also by legal decisions and by the statute. The banker will get a letter of lien executed by the customer who borrows the money against some collateral securities. The letter of lien mentions to the banker to hold them as securities, sell them for realizing his advances, that means to take back his advances. In case customer fails to redeem in essence, fails to pay back his dues on the due date without getting any orders from the court. So this is the meaning as to what is a particular lien and what is a general lien. Once we have understood what a lien is and what is a particular lien and a general lien is, let's further try to understand more on the concept of rights on general lien. There are certain conditions which has to be satisfied for enjoying the general lien by the banker. So banker can exercise general lien only when these conditions are fulfilled. Just like that, the bank cannot say, I'm exercising general lien. No, it cannot do it. It depends upon the following conditions which has to be fulfilled. What are those conditions? There are a few conditions being specified here. Those conditions are, there must not be any agreement inconsistent with the right of lien. What does it mean to say? Here the concept is, if you have taken a loan on a particular property and that loan what you have to be taken for that property should be related to each other. It must have some consistency, telling what I have taken is related to this. There should be no agreement of inconsistency. He tells I have taken for property A, but the property given to me for possession is property B. Then it is wrong. That means it is totally a wrong agreement. You cannot excise your general lien. Suppose you have to excise your general lien, then what is very much important is there must not be any agreement. There must not be any agreement inconsistent with the right of lien. The second thing, the property must come into the hands of the banker in his capacity as a qua-banker. What does it mean to say is, whatever the property for which the general lien is excised must be in the possession of the bank, not as a owner, but he must possess the property, telling unless and until you pay back the debts, I am the owner of the property. There is no transfer of the title to the property. It is only the possession given to the banker, telling you have a right to hold it unless and until the debts have been cleared. That is called as the property must come into the hands of the banker in his capacity as a qua-banker. The possession should be lawfully obtained. The possession should be lawfully obtained in his capacity as a banker. That means illegally the possession cannot be taken by the banker. It should be given by law. The possession of securities or whatever it is must be obtained by the banker lawfully. Very important thing is the property should not be entrusted to the banker for a specific purpose. You cannot give the property for any specific purpose. It should not be given for any other purpose. The goods or other securities must be in the name of the borrower. It should not be in somebody's name. It should be in the name of the borrower only and not jointly with any others. So these are the very important conditions. The very important conditions here is there must not be any agreement inconsistent with right of lien. The property must come into the hands of a banker in his capacity as a qua-banker. Possession should be lawfully obtained in his capacity as a banker. The property should not be entrusted to the banker for any specific purpose. The goods or other securities must be in the name of the borrower only and not jointly with others. Circumstances under which the banker cannot exercise the right of lien. What are these circumstances? When there is any contract inconsistent with this right between the banker and customers. See, what I was able to understand is the first point was conditions for right of general lien. That means you can exercise your general lien under the following conditions. But there are conditions and circumstances under which you cannot use the right of lien. What are those conditions then? Those conditions are when there is any contract inconsistent with the right. As I said, I have made an agreement for something, I have given something for you. Then you cannot exercise. So when there is any contract inconsistent with this right between the banker and the customer. Secondly, when the goods and securities are entrusted to the bank as a trustee or as an agent. Be very careful whenever you are given these goods to the bank as a trustee. Then you cannot go for general lien. So that is not possible there because you have a trustee-agent relationship there. When the goods and securities are entrusted for some specific purpose, if the purpose is different, then you cannot go for it. It is very clear. When the loan is granted to one person, the goods and securities are owned by more than one person. Then you cannot excise it. It should be only of the borrower, not of the borrower held jointly or with any other person. So you cannot hand it. When goods and securities handed over for safe custody, there also you cannot because it becomes another relationship. So you cannot go for general lien here. What relationship we discussed earlier, where it can be leasee-leaser, bailey-bailer relationship. When such relationship comes into existence, you can never exercise the right of lien. When goods and securities handed over for safe custody. And the bill of exchange or other documents have been handed over by the customers with specific instructions to utilize the proceeds for specific purpose. When you are given specific instructions to the banker telling it is for this purpose you should hand over this, otherwise you cannot use it for general lien. So it is very clear that a banker cannot exercise his right of general lien when there is any contract inconsistent with the right between the banker and customer, goods and securities are entrusted to the bank as a trustee or as an agent, when goods and securities are entrusted for some specific purpose, when the loan is granted to one person and the goods and securities are owned by more than one person, when goods securities handed over for safe custody, when the bill of exchange or other documents have been handed over by the customer with a specific instruction telling it should be utilized for this specific purpose only. And no lien can be exercised to which the customer has no valid title. That means is not a real owner. That is what I explained in one of the points. Is not a real owner. You cannot exercise the lien, general lien on it. Sometimes you have received some money on the sale of something. Even that cannot be exercised for general lien. So these are the situations and circumstances under which a banker cannot exercise his right of general lien. I think it's very clear that as far as the right of a bank is concerned, a bank has got a right to hold the property of the customer to recover his debts unless and until he pays it, only when he has certain conditions to be fulfilled and certain conditions not fulfilled, then he cannot exercise his right. I think we are able to understand that there is an existence of a special relationship even in these situations and circumstances between the banker and customer. The situation and circumstances are when there is a duty of a banker towards his customer and when there is a right of a banker towards his customer. Performing his duties and getting his rights also creates a relationship between the banker and the customer. There are various other aspects to further continue with the concept of the special relationship in our further content, which will be able to understand more on special relationships of the banker and the customer. I think the content being delivered is able to be understandable and to make you clearly understand, analyze the concepts, we have been developed an MCQ, that is multiple choice questions, which will enable you to analyze, justify your reasoning on the basis of understanding of the content. And thus when you do it, you will be more familiarized with the content. And I will conclude as of now. Thank you.